Hey, with our legal warriors, jury selection. Do you ever wonder how that actually works and what we think about as attorneys? We all watch these crime shows, real crime, all that type of stuff. Well, in this video, I'm going to tell you what we're thinking about, what the tips and tricks are, and how jury selection works. Stay tuned. This is a video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington state for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now, jumping right into it. Jury selection. At a basic level, what does that mean? Well, there's a process in our court system when it comes to both civil and criminal, but this is criminal. If you're charged with a crime, for the most part, you're going to have a right to have your fate decided by a jury of your peers. In Washington state, for felonies, it's a 12-person jury. And for non-felonies, it's a 6-person jury. And the process that is called in the legal system is voir dire. Or if I'm from the South, voir dire. Okay, it's called different things in different places. But basically, to make it short, it's the method in which we try to select jurors that can give each side, the prosecution and the defense, a fair trial. And it's a complicated process, and it may be one of the most important processes and the least well-practiced process by attorneys, I think, in the entire criminal justice system. So, how does it work? Well, a case has to get all the way to a jury trial before this even applies. So let's say the case has gotten through arraignment, pretrial motions. We haven't been able to settle the case, and now we want our day in court. And so a case gets called for jury trial, and there's going to be jurors, people from the public that have been summoned to do jury duty. I've been on a jury before, and I just got another summons for another jury duty. I guess I'm too popular. So what happens then is, let's say it's a non-felony jury in Washington state, that would be 6 jurors, let's say a DUI or an assault case or something like that. Well, the court is going to call so many jurors into the courtroom with the prosecutor there, maybe the law enforcement officer, the officer in charge, the defense attorney, the defendant, any people that are working on the defense team, because it can be a more than one person type process. And there's going to be prospective jurors brought in, maybe 18 for a 6-person jury, or 25, or maybe they only can bring in 12 because not many people showed up, right? So, and where do the jurors come from? Voter rolls, driver's license rolls. It may vary by county, vary by city, even how they do it. But basically, what's going to happen is in a 6-person selection process, they're going to usually draw random numbers for each juror and then set them in the box. So 6 people are going to be the sort of default jurors if no one gets kicked out, and then everyone else will also have a number drawn. And it can vary court by court, but the way I see it done mainly is, the 7th person would be next to be in a 6-person jury if we remove one of the first 6. Okay, and these jurors, prospective jurors, aren't total strangers to the parties because there's usually a questionnaire. We don't know them, but there's going to be a questionnaire that they'll fill out that the court may have given them, or in a really advanced case, maybe each party got to submit a questionnaire to the jury, or we got to sort of fight about what questions the prospective juror should answer beforehand. Hopefully we're going to know their name, we're going to know their age, we might know where they're from, we might know their profession, we might hopefully know if they've ever been involved in the legal system before. Do they work in the legal system? Have they had a civil suit against them or brought one? Have they been charged with a crime or been the victim of a crime? Stuff like that. And so what we would typically see then is, let's say John Smith was juror number 5, and I might find John Smith's questionnaire and then write a 5 on it. So I know that's who I'm talking to, because he's not going to have a name tag that says John Smith. Typically, there's going to be a juror number. So we're going to look through those. And now the court might ask the jurors some general questions. Does anyone here know the defendant? Does anyone here know the defense attorney or the police officer or the prosecutor or know the judge, right? And if so, then they're going to answer some questions about whether or not they can be unbiased or whether or not they just need to be removed immediately for cause due to that conflict. So once we get through that, then each side is typically going to have some time to question the jurors. And that's really what we talk about the voir dire. And for sake of this imaginary trial we're talking about, let's say it's a quick voir dire, that this is a lower level court and they want to move things along, and they're only going to give 15 minutes to each side to ask questions. Major felony might have hours of each side to ask questions. Things you see on TV, big murders and stuff, they might have days to find a jury. It might take that long to find a jury. So it's up to the discretion of the judge. But basically, each side is going to be asking questions of either the group as a whole, or we could ask an individual question to a certain juror to sort of see what we can learn about them, because the prosecution's trying to do their best guess to pick jurors who might be good for their side, and the defense is doing their best guess to try to pick jurors who might be good for the defense side. So let me give you an example of what we're thinking about. Let's say that my client is charged with assault. Well, I might want to know if a certain juror has ever known someone in their life that was a victim of assault, right? Someone close to them. If their daughter was a victim of some type of assault, they might feel pretty angry about somebody accused of that, given the personal experience that they've had in their life with somebody they care about being assaulted. So that's something I'm going to want to know. And it may not be easy to get that out of somebody, but that may be a bad juror for my client. Could be a good one, depending on specific facts. We're always taking our best guess, but that's part of what I'd be trying to find out. If I had a DUI case, maybe I want to know what someone's attitude is about drinking. I might want to know, is someone a teetotaler and doesn't drink and thinks drinking is evil in general? Well, that person might have a harder time giving a fair trial to someone not only accused of drinking, but drinking and driving, which of course is really bad. Don't do that. So that is what we're trying to do. And there's also broader things we're trying to do. Certain people in certain professions might be more likely to split the baby and do different things like that. But that's what we're trying to find out. So I promise some type of tip or trick. And I do this more for your interest, because you're probably not a defense attorney watching this, but sometimes it's hard to get jurors to share things that paint them in a negative light. We don't want to be seen negatively. We certainly don't want to be seen negatively in front of a group of people, right? We're tribal as far as our history. If we say bad things, we could be kicked out of the tribe. So it's pretty hard to do. So let's say I had a DUI driver and was my client, and they're accused of DUI, and let's say it's a borderline case. I might share something negative about my own opinions about things to get someone else to feel free to share their negative opinion. Reciprocity, right? If someone, gives us a flower, here's that flower as you're walking down the line. Well, give me some money for giving you the flower, right? Here's that CD I hand you for free. Can I now have a donation? You sort of feel like you want to reciprocate. Same way with this. So I might say, I hate to admit it, I'm a defense attorney, but I really sometimes don't think people charged with DUI should get any defense, because it's so irresponsible to have any drink and drive. Sometimes that's what I feel. Does anyone else feel like I do? So I shared something that may or may not be true for me, but in the way I'm putting it, it's true for me. And basically, that's encouraging someone else to share, yeah, I feel like you too. And that person might be a terrible juror for my client and would be unwilling to share that. If I said, hey, does everyone think that my client should get a fair defense even though they're accused of something really bad? Who's going to say no to that? Most people are going to say yes. So you can try to do advanced things to try to just get people to be more honest. I mean, that's all we're doing. We're trying to get people to be to tell about themselves, so each side can get a fair trial. So after each side goes through the questioning, then each side gets to start challenging jurors to remove them for something called cause. And or after that, we can use peremptory challenges, which is, hey, get rid of a juror without any excuse. So in that example where someone said, yeah, I don't think anyone who's charged with DUI should get a defense, the prosecution might try to rehabilitate them if they have more time, or the judge might try to rehabilitate them by saying, well, despite that, could you put aside your feelings and follow the law? That's a terrible question, in my opinion, for a court to ask. Sometimes we can file motions to try to stop the court from asking that because, again, in front of a bunch of people, we're going to say, yes, we'll follow the law, judge. And who's going to say, no, we're not going to follow the law? Not many people have those type of guts to stand up and really say how they feel because we want to see ourselves as fair and unbiased and be able to rise above our emotions. Reality, almost impossible to do. So we get to do challenges for cause. Well, I challenge number 6 for cause because they said they don't think anyone should have a fair trial who's charged with DUI. And the judge might say, yes, I agree, you're excused. So number 6 leaves, and whoever's next in line takes that person's spot, okay? And we've had to already ask people. We probably don't get a chance to ask any more questions. It's up to the judge. We're already stuck. So we have to even ask questions of people that aren't already in the default 6 that are likely to be the jury if no one is excused. So each side goes through challenges for cause, and then each side will get a certain number of peremptory challenges. Peremptory challenges is you can thank and excuse so many people without any reason. Now, you're not supposed to do it for protected class of people reasons, right? Gender, race, etc. And there's plenty of case law out there about certainly more likely, I think, prosecutors than defense attorneys excluding certain people due to race. It could go both ways. But there's case law where we've seen some certain prosecutions exclude all the minorities for no good reason because there's a minority on trial would be what the bad version of the reason might be that the defense would assert because we know that race plays a role in everything in life. So each side goes through their certain number of peremptories. And then once we've gone through as many as we're allowed, oftentimes 2 or 3, then the jury is set. So once the jury is set and the jury will be sworn in, the judge may choose to swear in an alternate or a couple alternates in case someone can no longer serve, they get sick, or they commit misconduct. There's usually going to be some type of alternate. Sometimes they won't know which one the alternate is. Sometimes there'll be a bunch and they're going to pick an alternate at random and don't tell them. That way they remember, everyone pays attention, right? If you don't know if you're the alternate or not, then you're more likely to pay attention. If you know, my opinion's not going to count anyway, well, you might just be, working on your nails or tying your shoes while the case is going on, right? So the jury's sworn in, and then the rest of the prospective jurors are excused. So I know this has been a bit of a detail, and there's lots of different ways that can happen. And I've done my share of jury trials, but I'm no ultimate authority. I'm just giving you an idea of exactly what we're thinking. There's strategy going on because who makes the decision in the case matters a ton. It doesn't quite control the outcome, but it almost does. So I hope you've got some education from this. I hope you never have to go through this, but I hope it gives you some more insight about what you might see out there when you see a jury trial going on TV, on YouTube, or wherever. So if you find this useful, please like and please subscribe. More people get the help they need. And more importantly, if you have a legal problem, you have a criminal matter in Washington State, please feel free to reach out to my firm. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.